Experts are involved in a number of ways when it comes to enforcement proceedings. So primarily you'll have lawyers and barristers because when you're actually undertaking an enforcement process, they generally tend to actually drive the process forwards. Also what is key is actually identifying assets. So very often you're going to instruct some corporate intelligence experts who've got the ability to undertake investigations, to identify assets, to identify what assets belong to a business. And then you'll be looking at actually instructing valuations experts, and the reason for bringing those in is because you need to understand the actual value that exists within different asset classes, whether that's property or whether it's actually a business which is trading, and you need to understand the underlying value of that business. And then finally you'll be looking to bring in insolvency practitioners to act as receivers or actually as liquidators or trustees in bankruptcy, for example, to actually take control of assets, realise them and then distribute them to the claimants. I would say that experts should be brought in as soon as possible when looking at enforcement. I think it's much easier to actually bring in an expert when you're already involved in the litigation and actually you are looking to make recoveries in the process of litigation, and very often it's easier when you're already spending money, bringing claims, to actually bring experts in to assist. If you're fighting some litigation hard or arbitration hard, it's pretty obvious that you're going to have challenges around enforcement, so you should bring them in as soon as possible. Very often I get approached far too late in the process, and it's much harder then to actually enforce and actually have a successful outcome. So always look with the lawyers advising you as to whether there are angles or opportunities to start some form of enforcement process as soon as possible. I think the most novel tools that I'm seeing at the moment in terms of enforcing awards are around people actually understanding the businesses that defendants might own or assets that defendants have, and then identifying routes into taking control of those particular asset classes. So for example, we have been approached to act as receiver over claims being pursued in litigation by a party who is a defendant to the original claim. We can then act as receiver over that particular claim and then benefit from any recoveries that are made from it at a future date. Or finding ways within the business and how it trades as to whether you can actually enforce against specific assets within that. So that might be something to do with the supply chain, or it might be a key component of the business. For example, if you are against an airline, can you actually take control and seize, for example, the oil that keeps, or the fuel that keeps the planes in the air and the business trading. In terms of different jurisdictions, enforcement proceedings can differ in a large number of ways. So for example, in the UK, there is a well-established legal system which aids claimants with things like freezing orders. There's a well-established insolvency regime for enforcement. If you move outside the UK, though, to certain jurisdictions where they are less sophisticated, they don't necessarily have the same approach and actually find the concepts of enforcement quite unusual. What I have found is that most of the offshore jurisdictions, typically BVI, Cyprus, Singapore, are all open to the concepts of enforcement and they will provide the necessary assistance. It's really the onshore markets that are particularly difficult. So I would say that what you need to have is proper local expertise, and that might mean switching your law firm. You need proper local advisors, and also always focus on what the end result is, and make sure that when you're instructing those advisors, they actually know what you're trying to achieve in the process.